With the concern of opposite parties, I beg to mention item number 9 of today's list. My senior PM today is not fully prepared with the matter to do. Can I do some other paper?
I think so many matters are fixed for hearing. Many of the appeals are fixed. We'll take up all fixed matters out of those. It is not possible to take up. So it will be left. Nine. Not pass any order.
Left resolution. But,
What are the fixed? Let me find out.
item 7.
Any person from item number 1 is available? Okay. 2, 2, 2. 3. 3. And 4. How does Sahari doesn't submit 13. 7 years, 7 years, 7 years. Okay. We'll concentrate on 1 to 5 and 13. Others not.
So far as 6 is concerned, if your assistant fix a date, your
We'll find out.
on 24.
We'll find out.
Not even item number 2, you expect.
We'll also take note of the period of detention also.
Lots.
Right. Others are 7 years, someone is 12 years.
Lots.
So we are taking note of that fact.
Malhotra,
1 to 5 and 13. Others, other items we may not.
7 will be next week, item 7.
Item number, yeah. Item number 2, media.
We'll see, we'll see. We'll see. You wait.
Out of
We'll replace. We'll replace the amendments.
May I please your receipt? I'm praying from requisition and additional affidavit in connection with item number 12. God bless.
Okay, bring. Matok item number 12.
Lordship, item number 11, Lordship, I'm allowed to withdraw the Lordship. With
Item
regard-
number
1, 11, Lordship.
11.
Yes, Lordship.
Okay.
Lordship.
Now you don't know the place of detention.
Yes, Lordship.
Purpose of habeas corpus is
Okay.
attained.
Lordship, yes.
attained.
Yes, Lordship. It is not a illegal.
We can, Mr. Nath, we can record that the person named so-and-so is detained presently in a detention camp at Motia, Gwalpara.
Lordship, with due respect, Lordship, so one copy if furnished the expert in judgment passed by the DPU Lordship. I have not available.
That can be, sure.
Yes, Lordship.
Heard Mr. R.C. Das, learned counsel for the petition, and Mr. D. Nath, learned senior government advocate Assam for the state response. Where the instant writ petition is preferred, seeking a writ in the nature of habeas corpus in respect of 1. Abdul Salam alias Abdus Salam was destroyed, was the global son of Ali Hussein, post Mr. Nath, learned senior government advocate Assam, comma, on the basis of instructions he has received, comma, has submitted that pursuant to an order stroke opinion passed or dated 27/9/2023, passed by the Foreigners Tribunal, DIFU, in FT case number 205/2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 /2009, 2 0 5 the said person has been detained and apprehended as a declared foreign national and has been handed over to the border branch of the Superintendent of Police, Karbi Anglong Depot for verification of records and for uploading his biometrics in Foreigners Identification Portal within bracket FIP. Full stop. He has further submitted that on completion of the said procedure, the person has been forwarded to the holding area located at Motia, Gwalpara. And at present, the person is at the detention camp. It is called detention camp or what? What is the name?
It is Matia detention.
Matia Detention Camp, Gwalpara. Full stop. Mr. Das Learned Counsel, by paying for the petitioner, has submitted that he may be furnished with a copy of the order dated 27/9/2023 passed by the Foreigners Tribunal, Karbi Anglong Depot in FT case number 205/2009. Mr. Nath, the senior government advocate, is to furnish a copy,
Yes,
has furnished a copy of the order dated 27/9/2023 Supra to Mr. Das. Mr. Das, learned talks about the petition, has submitted that the petition, he may be allowed to withdraw the petition to seek appropriate remedy under the law. In view of the above submission made by the learned counsel for the petition, and the petition is dismissed on mutual with the liberty as paid for.
yes. Master. Lordship, as so far concerned, Lordship, the item number 12, Lordship. So here I have one additional affidavit, Lordship. So there are, in this Lordship, I have appended the 3 documents, Lordship.
Hmm?
3 documents I have appended, Lordship.
Hmm.
So one, PAN card, Aadhaar card, and the birth certificate, Lordship. So I have copy, Lordship.
PAN card is already there,
No, Lordship, the voter ID is only there, Lordship.
huh?
So I have copy, Lordship, extra copy.
Then you file an affidavit, we issue notice. Otherwise, according to আগৰ কাগজখন লৈ ফাইলত থকা দুইটা সেপাৰেট কৰিব লাগিব। পিনটো ক্লক
Here also, my instruction is that, here also my instruction is that he is a declared foreigner. There is an ex parte order. And he has been detained by police as per the judgment. After the verification process, he has been sent to detention camp. Now he has filed an additional paper to dispute with that, he paper I'll file it. Otherwise, the whereabouts of the person is known. As of
now whatever is known, purpose of habeas corpus is
it is-
otherwise
So
it's
Lordship,
complete, but if it is on affidavit, it is better for us to dispose of.
Look,
Lordship, I will do respect.
If it is a case of mistaken ID, that is a different issue.
the father's name they claim to be there.
Abdul Salam. Abdul Salam or what? Amiruddin, to Amiruddin. এখানে একটু থৈ দিয়ক। Then you file an affidavit.
I'll file.
Otherwise, it is known. We'll record that.
I'll file. Otherwise, if wherever is.
Heard Mr. R.C. does. Short notice then. File an
Sure.
affidavit.
Yes.
Since it is a writ of habeas corpus.
Yes,
And Mr. R.C. Das, then I counsel for the petitioner. And Mr. S. Dinath, Learned Senior Government Advocate. Some for all the respondents. Full stop. The incident petition under Article 236 of the Constitution is referred seeking issuance of a writ in the nature of habeas corpus. on the premise that one person named Amir Uddin.
Amir Uddin.
AMIR space Uddin alias Mohammad HMOHAMMAD Amir space Uddin, aged about 38 years, son of Lalumia, has been illegally detained by the respondent authorities. Para Mr. Nath, learned senior government advocate, on the basis of instructions he has received, has submitted that the person named Amir Uddin, one person named Amir Uddin, Muhammad Amir Uddin, son of late Nur Islam, has been, was declared a foreigner by an order stroke opinion stroke order dated 7/2/2016, passed by the Foreigners Tribunal Karbi Anglong at Difu in FT case number 12/2010. Post-op. The said person has been apprehended as a declared foreign national and thereafter handed over to the border branch of the Superintendent of Police, Karbi Anglong Difu, for verification of records and for uploading his biometrics in the Foreigners Identification Portal, in bracket FIP. Post-op. On completion of the necessary procedure, the person has been forwarded to the holding area located at Motia, Gwalpara. And at present, the person is at the detention camp at Motia, Gwalpara. Post-op. Para Mr. Das, the counsel for the petitioner has submitted that the petitioner, an additional affidavit is filed in the case by furnishing a copy to Mr. Nath today, by furnishing a copy to Mr. Nath. Also, Mr. Das has further submitted that there could be a mistaken identity in apprehending the person named Amir Uddin, alias so-and-so. Post-op. The matter would require consideration and issue notice. Returnable on 23rd,
Lordship,
no, before that, 20,
before that.
20.
Lordship,
I think yes, I think right. Let it be 16 then.
Lordship,
16.
till the returnable lordship, I am allowed to interim lordship is because the other name is not matched lordship, so that's why lordship.
No, your things are also not matching.
No,
Your
lordship,
things are, your identities are also not matching.
lordship, so concern of the date of birth lordship, in a voter ID lordship is a concerned department wrongly recorded lordship, is a.
Wrongly recorded is not,
Lordship, another document.
wrongly recorded is not a good plea at this stage. That would require determination.
Lordship may take it on 16, before that I'll file it.
Because what is the purpose of habeas corpus? We'll examine that mistaken identity, if it is a mistaken identity. Otherwise, your presence is now known. What is the purpose of habeas corpus?
Section 47 lordship, which is violated lordship, the concern.
What violated?
So concern
No,
police
that does not
lordship-
come if,
So
if it is not a case of arrest, sir, or not a case of preventive detention.
So if
It
the-
is a detention simpliciter.
if the wrongly arrested,
It is not under NSA, not under PIT NDPS or any other preventive detention laws. It is not under any criminal law.
But concern
It is a unique situation. It is under Foreigners Act. Right?
Yes, Lordship, but concern is. Lordship, that
Foreigners Act.
police-
So natural consequence after an opinion of a foreigners tribunal, if the higher court is not granting any relief or bail or not to arrest, the apprehension and detention.
I agree.
Now question is about, you are also not sure what is his identity. So we are making it very short
Yes, yes,
to the extent possible.
yes,
We'll find out.
yes. Lordship. For that. kind.
We'll have to find whether his detention is illegal or not illegal.
Yes.
If illegal, we'll direct his release.
Yes, yes,
But for that, they have to be given an opportunity, sir.
yes, Lordship.
You should notice returnable on 16. As Mr. Nath has yet accepted. Formally dispensed with extra copies during the course of the day. The respondent shall ensure that its counter affidavit is filed on or before the returnable date.
And Lordship, if with Lordship extra copy is the expert degree Lordship. It will. Oh, yes,
He'll give.
yes, yes. Master.
Wait, please, Lordship. Lordship, earlier this matter had come up for hearing. In fact, order dated 14/5 says so, that endeavor will be made. I'm ready to.
It is ordered according.
Chief, the FIR starts at page 1. Relevant portion is at page 4 of the paper book.
When it was lodged,
At around 36, 2015. Page 4, my lord. Humble submission is that around 9:30 PM on 29/6/15, while my father Gyasuddin, 70, was sitting inside his home, the aforementioned accused came inside the house holding a dagger in his hands, cornered my father and killed him by stabbing him on his back, chest, and hands with the dagger. Therefore, it is prayed to take necessary action after investigating the incident and oblige. Now, the informant is my brother. It is the case of son killing his father. Charges were failed, where he had pleaded not guilty for section 302 and claimed to be tried. My lord, PW1, evidence is at page 8. He is the informant. PW1, I am the informant of this case. Deceased Gyasuddin was my father. Accused was my own brother. Occurrence took place in the last Ramjan at around 9:10 PM. On that day, I was at my own house. My deceased father and accused lived together. I live with my family across the road in front of the house of the accused. Hearing disturbance, I went there. My other brothers also assembled there. The door of the house was closed from inside. By forcibly opening the door, we went inside the room and have seen my father lying on the ground in injured condition. The accused was standing there holding a dagger in his hand. When we caught hold of the accused and tied him with a rope and kept him there. Subsequently, police was informed. Police arrived there after an hour. After a short while, my father died. My father sustained injury on his hand and belly. Police seized the said dagger in our presence. I filed the ejahar. I put my thumb impression in the seizure list. I have seen the said dagger in the court today, which was seized by police. Cross my lord. I have forgotten the name of the person who wrote the FIR. At the time, I was not in sense. We have 5 brothers. Accused is 4th in number. We all live separately. Accused was in mental hospital Tejpur prior to 3-4 months of this incident. He was on medication. At the time of incident, medication was going on. All except myself, rest of my brothers live in the same campus. It is not a fact that I have not stated before the police that hearing sound of my father, I went there.
I have not seen the actual incident. It is not a fact that the accused was not in sense at the time of incident. Now, PW2, he is another brother, my lord. Informant, it's page 9. Informant is my elder brother. Deceased was my father. Accused is my brother. Occurrence took place around 1 year back at night hour. I was sleeping in my house. Hearing halla, I woke up from sleep. Then I went to the house of my father along with other brothers and found the door locked from inside. Then we got the door broken by force. On entering the room, I have seen that my father laying on the ground in an injured condition. The accused was standing in the room with a dagger in his hand. My father died after a short while. Then we tied the accused and kept him there. Police seized the dagger. Exhibit 1 is the scissor list. Exhibit 1 is my signature. Material Exhibit 1 is the said dagger. Cross. Hearing halla, apart from my brothers, Unus Ali and Azhar Ali went to the PO, and we have seen our father lying on the ground inside the house. We all live separately from each other. The accused is an insane person. As because my brother accused was mentally ill, my father kept the accused with him. He was on medication at that time. We have not seen the actual incident of assault. After around half and 1 hour, police came there. After the incident, a crowd of 50-60 people assembled at that spot. PW3, my lord. He is also a family member. Informant is my nephew. Deceased Ghiyasuddin is my elder brother. Accused Abdul Bashar is my nephew. Accused was the son of the deceased. Occurrence took place around 6-7 months back at around 9-10 p.m. On the day of incident, accused and the deceased staying on the same house. At the relevant time, hearing halla coming from the house of my brother, I went there and have seen the accused tied with a rope by some person. They told me that accused murdered his father. I have seen the dead body of the deceased lying on the ground with injury marks on chest. I have seen one dagger. Police seized the dagger and put my thumb impression on the scissor list. Cross. I have not seen the dagger today in courtroom. My house is a little distance away and the house from the house of the deceased. In between there are no other houses. I have not seen the actual occurrence. The house of Sahabuddin is at the north side of the house of the deceased. Accused was suffering from mental illness. He was also taken to Tejpur Mental Hospital and kept there. It is not a fact that I have not seen the accused tied with a rope by some people and accused murdered his father. PW4, my lord, at page 11. I know the informant. I also know the deceased Ghiyasuddin. Accused Abul Bashar is known to me. Occurrence took place on the month of Ramjan last year at 9 p.m. I am the next door neighbor of the deceased. At the relevant time, I was sleeping inside my house. On hearing halla, I went to the house of the deceased. Accused and deceased were son and father, and they resided in the same house. On reaching there, I found the body of Ghiyasuddin lying on the floor inside the house. I have also seen marks of injuries on his body. He was lying on a pool of blood. Accused was kept tied inside the house with a rope. Cross. The accused was suffering from mental illness. He was once admitted in Tejpur Mental Hospital. Before this incident, his treatment was going on. The village people know him as mentally ill person. I have not seen the accused murder his father. PW5, my lord. Page 12. He's also a relative. I know the informant, deceased and accused. They are of my same village. Occurrence took place on 7th day of month of Ramjan last year at about 9-10 p.m. At that time, I was sleeping inside my house. Hearing halla, I along with my husband and others went to the house of deceased. Other village people also gathered there. They entered into the house of the accused by breaking the door. On entering the room, I have seen accused Abul Bashar standing inside the room holding a dagger in his hand. Then village people tied him with a rope. I have also seen Ghiyasuddin lying on the ground in a pool of blood. Deceased died at the spot. Cross. Accused Abdul Bashar is my brother-in-law. My husband has 2 sisters and 5 brothers. We all live separately. There was no partition in respect of property. On reaching there, I have seen 10-12 people at the spot. Others came later. I have not seen the said dagger in court today. It is not a fact that I have not seen the accused standing inside the room holding a dagger in his hand. PW6 is the doctor who conducted the postmortem. At page 13. I did the postmortem of Ghiyasuddin, son of so-and-so of village so-and-so, on 30/6/2015 at about 2:30 p.m. The body was carried and identified by UBC 373 Deposit Borgohain. Muhammad Nazrul Islam and Muhammad Abdul Aziz. Findings: walls, ribs, and cartilages fractured at both sides at different level, mentioned as both description. My lord, injuries are mentioned in the last part of that page. Injuries, there are 5 injuries, my lord. Incised wounds piercing on the front of the left side of chest, 6 centimeter from mid divide, 4 centimeter into 1.5 centimeter,
Piercing the heart.
heart. 2. Incised piercing wound in left chest back, 3 centimeter into 1 centimeter. Incised piercing wound in left shoulder, 4 centimeter into 2 centimeter, 2 centimeter. 4. Incised piercing wound in the right infrascapular region. 5. Incised piercing wound in left hand medieval aspect, avulsion in type. Opinion. In my opinion, the cause of death is due to shock and hemorrhage as a result of multiple injuries resulting injury to the major vessels and heart as a result of sharp force. Cross. I have not mentioned type of weapon used in such of incident in my report. Approximate duration of death is not mentioned in PM report. There are 5 injuries. PW7, my lord. He is also a relative. I know the informant. This is Gyasuddin was my father-in-law. Informant is my brother-in-law. Accused Abdul Bashar is also my brother-in-law. Occurrence took place around 8-9 months back at 9:10 p.m. At that time, I was sleeping in my house. Accused and the deceased slept in a separate house. Hearing cries of my father-in-law, I woke up. I went to the said house and have seen accused murdering his father. I have seen my father-in-law lying on the ground in a pool of blood, and accused was standing inside the room holding a dagger in his hand. Cross. We all reside separately in different houses. Deceased and accused reside together. My house lays about 25 feet away from the place of occurrence. There are 5 brothers and 1 sister. Brothers of the accused went to the PO first. I followed them. Neighboring people came there. Siraj Ali, Saha Ali, Rafiqul, and others came there at that time. About 3-4 months back, the accused was taken back from mental hospital, Tejpur. The accused was suffering from mental illness and he used to take sleeping pills. On that particular night, I had given him the prescribed medicine after the night meal. When I entered the room, I had seen the deceased lying on the floor in a pool of blood, and accused was standing there with a dagger in his hand. PW8 is the IO, my lord, at page 16. On 29/6/2015, I was officiating as in charge at Heloguri police station. On that day at 9:45 p.m., I received a call from one BDP secretary named Amsar Ali, who told me that a murder incident occurred in Hasora village. Then I made a GD entry, right GD entry number 573 dated 29/6/2015. Exhibit 4 is the extract copy of the same GD. Then I proceeded to PO with a team of police. I reached the house of the deceased Gyasuddin. In one of the rooms of his house, I found the dead body of the deceased Gyasuddin lying on the floor, and his head was pointing upward. I have also found accused Abdul Bashar being detained by the village people. I found one dagger from the accused. I seized the dagger in presence of witnesses. Exhibit 1 is the said seizure list. Exhibit 1-4 is my signature. As because it was dark night and there is very little light in the room, inquest cannot be done at that time. Then I brought the accused to the PS. On the following day, I received a written ejahar from one Moinul Haq, who is the son of deceased Gyasuddin. Then I questioned the accused regarding the matter. Having found materials, I arrested the accused and paused his production before a learned court, wherefrom he was sent to judicial custody. Exhibit 5 is the ejahar filed by Moinul Haq. 5-1 is my signature. Material Exhibit 1 is the dagger seized by me. On the following day, the inquest over the dead body was made and sent to Morigaon Hospital for postmortem. Exhibit 6 is the inquest report. 6-1 is my signature. Exhibit 7 is the sketch map, and 7-1 is my signature. I almost completed the investigation process. Charge sheet was filed by SI Abdul Sattar Chaudhary. Exhibit 8 is the state charge sheet. 8-1 is the signature of SI Abdul Sattar Chaudhary. Cross. As because I did not submit charge sheet, I did not enclose the extract copy of GD entry in the case. Exhibit 4 is not the extract copy of the GD entry. It is a part of the CD. I did not examine Amsar Ali, who informed about the incident over phone. The witnesses I examined are relatives of the deceased. I did not send the seized dagger to FSL for examination. The ejahar was received on 30/6/2015 at about 8:30 a.m. I have not mentioned in my sketch map as regarding the distance of the houses of the deceased from the house of the deceased. Now, my lord, going by the evidence, everyone in their cross have stated that the person was suffering from mental illness. Then comes his 313 statement, page 18. My lord, every answer, he says, first, it is alleged that on 29th day of June 2015 at about 9:30 p.m. at so and so ward number 10 under Bheloguri PS, you committed murder intentionally causing death of Gyasuddin, your own father. What do you have to say? Yes, I murdered my father. Everything he says, yes, yes, yes. But question number 11 at page 21. What else do you want to add? I love my village girl named, well, some starts with A, Anju. Anju, and I wanted to marry her. And when I told this to my father, the deceased, he did not agree. On that night, I took a dagger from the house of my, and murdered the deceased by using it. He admits he has killed it. Now, my lord, going by all this, this is the evidence. There's no discrepancy in any of the evidence. Everybody has stated he had mental issues. If your lordship comes to the impugned judgment, that starts at page 23. The evidence has been laid down. I'm relying on page 33, my lord.
Yes.
Page 33, my lord, third paragraph, starts with during argument. During argument, the learned defense counsel has drawn my attention to the cross-examination of PWs that the accused person was suffering from some mental illness for which he took treatment at Tejpur Mental Hospital. However, during proceeding of the case, the accused or the defense did not take any plea with regard to any kind of mental illness of the accused at the time of occurrence of the incident. Moreover, jail authority also did not make any application before the court giving any information regarding mental illness of the accused. That apart, the prosecution witness, who are the brothers and other relatives of the accused, also failed to produce any documentary proof of mental illness of the accused at the time of occurrence of the incident. Hence, in the absence of any cogent proof with regard to mental illness of the accused, this court cannot hold that the accused was suffering from any kind of mental illness at the time of occurrence. My lord, under this aspect, my lord, if your lordship takes up the Evidence Act, Evidence Act section 165, my lord.
Okay, just a minute.
My lord. Otherwise, CRPC, my lord, 329, the provision when a mentally unsound person is to be tried. I read it, my lord, 329. Section 329, CRPC. Procedure in case of person of unsound mind tried before court. If at the trial of any person before a magistrate or court of session, it appears to the magistrate or court that such person is of unsound mind and consequently incapable of making his defense, the magistrate or court shall, in the first instance, try the fact of some unsoundness and incapacity, and if the magistrate or court, after considering such medical and other evidence as may be produced before him or it, is satisfied of the fact, he or it shall record a finding to that effect and shall postpone further proceedings in this case. Now, the PW1 informant on the first instance itself has said that his brother was suffering from mental illness. It was brought to the notice of the court.
Yes.
But the LCR subject to correction, after he was arrested, when he was produced before the magistrate court, there's an order that he be treated for injuries because when during his time of arrest, he had sustained some injuries. Apart from that, there is no mention of any mental illness or anything. Subject to correction matter, I could not find it.
The accused did not move any application.
No, my lord. My lord, that's my next point actually. He was given a legal aid counsel because he said he could not afford anyone. Even then, my lord, your lordship takes up 165 of the Evidence Act. One sixty-five of the Evidence Act. Judge's power to put questions or order production. The judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witness or of the parties about any fact relevant or irrelevant, and may order the production of any document or thing, and neither the parties nor their agents shall be entitled to make any objection to any such question or order, nor without the leave of the court to cross-examine any witness upon any answer given in reply to such question. Now, my lord, the trial judge in the paragraph, in that paragraph under, in page 33 of the judgment, he has said that we had not produced any document. The 5 witnesses out of 8 witnesses.
Was saying also.
My lord, my lord.
Mr. Parasai ji, you have to see the situation also. It is not that these relatives are independent witnesses.
Hmm.
They are related witnesses.
My lord.
They are equidistant from the appellant as well
Right.
as the deceased.
Right.
In the chief, the trend is evident. I
Right.
saw 161. There was nothing,
Nothing.
absolutely nothing about mental,
Right.
right? But in the chief also, they abided by the 161 statement,
Right.
right? And the cross, there is a consistent trend. Saying the truth is one part, and taking a consistent, I don't know what word,
I understand. Lordship.
manner,
I understand.
that is one, because see, here is a case where the deceased and the appellant are almost equidistant
From every-
in relation from these witnesses. So we need to have a careful look also.
I
That
understand.
I know the law to that extent, at least some 329. You cannot say that legal, I think legal aid counsel are of what experience to conduct a murder case? Supreme Court has laid down a law.
7 years. 7
Ah.
years.
It is not that, but subtly he has taken a stand. It is not that he has not taken a stand. To carve out the general exception to bring out the exception under section 84 IPC. A trend is there in this case that it might fall under section 84. Though it is a case of 302, in a manner, because it appears otherwise has adopted a good one. I don't know the correct fact he is mentally ill or not, but on the part of the legal aid counsel, at least he had tried to take out the case out of the exception. Because he is the one who has cross-examined. He is the one who has counseled, right? And everybody said treatment in Chespur. Somebody said 2-3 said treatment. Somebody said he is under meditation. So what the trial court said that nothing has been
Done
placed
on-
before dispute.
Yes, ma'am. Yes.
There is another aspect that to invoke 329. Whether to invoke or not to invoke, it is for the trial judge. And a court of session is considered to be a highly trained judicial mind. So we cannot also say something without knowing. He is the person who has direct interaction with the accused, right? Now 329, it appears to the magistrate or court that such person is of unsound mind and consequently incapable of making his defense. This is the part.
This is the part. And my submission here is there are 8 witnesses. Suppose only one said that he is suffering mental illness. I understand. My lord, all the witnesses, PW1, from PW1, he has said that he is suffering from mental illness. What is the procedure? It has come to the knowledge of the court. Rightly, wrongly, it's a different thing. It has come to the knowledge of the court. The procedure should have been, trial should have been stopped there. And 1A then, my lord. 329 1A. If during trial, the magistrate or court of session finds the accused to be of unsound mind, he or it shall refer such person to a psychiatric or clinical psychologist for care and treatment, and the psychiatrist or clinical psychologist, as the case may be, shall report to the magistrate whether the accused is suffering from unsoundness of mind. In fact, my lord, there are 2 things. Your lordship has said section 84. 84 comes at that point of time when the incident has happened. It may so happen, there may be cases, suppose I am mentally unsound now, I do something, subsequently I recover from it, then I can face trial. It may so also happen that during the fact when it has happened, I was completely of sound mind, but during trial I'm unsound. I cannot face trial, I cannot enter defense. That is the purport of 329. If anything comes before the court, that something is wrong with the person's mental health, the
But
trial
there
should
are
have
2
stopped.
ways of doing it.
I know.
Mr. Protesi, I had done it myself. I have invoked as a lawyer 329. Got the person acquitted.
I also had the benefit.
So
My learned friend was-
I know the process. There are 2 ways of doing it. One is the court finds. The other is at the instance of the
Yeah, accused.
appellant. Out of 2, there is none from the second way.
No,
The second way.
yes.
Though
Cross-examination. party-
subtly, a
Yes.
cross-examination, the trend of cross-examination is that in spite of taking that, there was no application. Because in that case, the court would have been bound to do it.
Right.
Right, under subsection 2 of section 320.
Right.
Right. But so far as one A is concerned, it is the court who has to find. And thereafter refer.
My-
I think this is the
Yes, yes.
way to go forward perhaps.
Now, how, there's
Now-
definition.
It is the court who has interacted with the accused. He has the direct interaction during the trial with the accused. We cannot visualize something. And at the same time, we cannot be oblivious of the fact, the other circumstances. So do you have, as on date, anything of any medical record?
Yes, yes, madam. Your lordship has ordered the Morigaon district jail.
No, no,
asking-
that is as of date.
Oh.
That is as
No,
of date,
that ti-
sir.
That time there's nothing,
That
my
is
lord.
as of date.
That
That
time-
is-
That is why I'm
If
relying
he
on.
is found of unsound mind, as of date, he will be treated in a different manner.
Yes, yes,
Right?
yes,
And
I agree, I agree.
Prison manual takes care of it, or other act laws will take care of it. But we are on the matter of, what do you say? This is a case of bringing out a case, because trend is bringing out a case
Of mental
out of 84.
My-
Looks like,
my-
it looks like from the trend of cross-examination. Now, what is your submission?
my lord, on that day during trial, there are no documents. I admit to that. There are no documents or anything which has been produced before the court that he was of unsound mind. That is why I'm relying on my lord 165. Evidence Act. But I still say, had it been 4, 5 witnesses and amongst them only one says, I understand. 165 clearly says, my lord, judge's power to put questions or order production. A judge may, in order to discover or to obtain proper proof of relevant facts, ask any question he pleases in any form at any time of any witness or of parties about any relevant fact or irrelevant, and may order the production of any document or thing. The Supreme Court, relying on this provision, my lord, has gone to the extent of saying a trial judge is not just someone who's going to record the evidence. He has to get inside it. Under in cross-examination, that is the only way of putting forward the case of the accused at the first instance. So case of,
Yes, but at the same time, there was indication.
my lord, yes, I understand.
There was indication also that he was, let us see once again the trend.
And a page
He
8
was
is-
on medication at that time.
yes, ma'am, page 8.
PW2 says,
In fact, my lord, page 8, why I am relying on 165.
then he says, accused was in mental hospital,
Page
stressful prior
yes,
to
ma'am.
3-4 months of this incident. He was on medication.
PW2 says. 3 says accused is an insane person, he was on medication. Doesn't say about hospital.
She says he was there. He was also taken up in Tezpur mental hospital, kept there.
3, or 2 says, 2 does not say, my lord, 2 does
He
not say.
says, 4 says.
3 says Tezpur mental
Four
hospital,
also admitted.
4 also mental hospital.
Yes.
Then my lord, 7. 7 also says mental hospital Tezpur. Except 1 out of 5 says mental hospital Tezpur. Now in that situation, my lord, 165 plays the major part. The court could, on its own motion, could have asked. And it is not that incident has occurred
We
now.
will look into it.
My lord, one more thing why I want to point it out, there's a judgment of this court. The division bench judgment, the citation is 2012 1 GLR 115. My lord will take page, para 37 at page 125. Para 37, page 125. As provided by section 329
One
CRPC.
minute.
My lord. May I read it, ma'am?
Para?
37, page 125. Page number is on the top. As provided by section 329 CRPC, the trial court dealing with a person of unsound mind in the first instance is required to try the fact of such unsoundness and incapacity. In the present case, as per the report issued by, now this is the Tezpur Hospital short form, Tezpur, the accused has recovered considerably, thereby meaning that he did not recover fully. That apart, subsequently he was required to be sent to psychiatric department Silchar. The trial court on the basis of the report issued by the petitioner, psychiatric department Silchar, concluded that the accused was fit to face trial. In fact, the learned judge neither recorded as to what were the findings regarding the mental health of the accused, nor examined the medical officers who examined and treated the accused and submitted the reports. Therefore, it is found that the learned trial judge did not try the fact regarding the unsoundness and incapacity of the accused. Then, my lord, para 45, sorry, 45. My lord, to take 41 also.
It is a established case of schizophrenia,
Yes, our case,
this one.
our present case.
No, this which you have cited.
Yes, yes, ma'am.
So it is an
Established
established
case
case of schizophrenia.
Schizophrenia, yes, ma'am. Now, para 41. Considering entire aspect of the matter, we have no hesitation to hold that the accused was suffering from mental disorder. This part is important. The examination of the accused under section 313 CRPC is a statutory obligation and not a mere formality. The purpose of such examination is to provide sufficient opportunity to the accused person to explain circumstances and incriminating evidence brought against him. During such examination, the attention of the accused is required to be invited to the incriminating evidence and the circumstantial evidence relating to the offense for which he has been charged. It provides the opportunity to the accused to state before the court as to what is the truth and what is his defense in accordance with the law. Therefore, before an accused is examined under section 313 CRPC, court must ascertain that the accused person is mentally fit to properly understand the legal implications of the incriminating evidence materials brought against him and the questions put to him. Unless he properly understands the legal implications, the consequences thereof.
Why you say this fact section 41 is important?
Section this one. Why, my lord? If
The
your lordship-
para,
Yes, my lord. I'll come.
para 41.
Lordship, if
Just because he has admitted,
no, my lord. If your lordship come takes para 45 now. Squarely covers us. Para 45. Fact remains that at the time of framing the charge, the accused person categorically denied the charge brought against him and he claimed to be tried. There is no explanation as to what prompted the accused person to admit the allegations brought against him at the time of his examination under 313 CRPC. Considering the mental condition of the accused as indicated above, it is doubtful if he understood the implications and legal consequences of giving the answers in the way said. This is why I'm relying, my lord. My argument on the very first day, the PW1, after the 2, 3, 4, and 8, 7, they have said that there is something wrong with him. Before traversing to 313, before traversing to recording 313, I would say trial should have stopped there. After all the evidence, after PW8 was examined, trial should have stopped there. Then the court should have gone to find out if he's actually mentally unsound, because that was the stage he was supposed to enter his defense. Because my lord will know, Rina Hazarika has made it very clear that it is not an ad alteram partem just. If your lordship takes up 465 CRPC. Finding or sentence when reversible by reason or error, omission or irregularity. Subject to the provisions herein before contained, no finding, sentence or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation or revision on account of any error, omission or irregularity in the complaint, summons, warrant, proclamation, order, judgment or other proceedings before or during trial, or in any inquiry or other proceedings under this court, or in any error or irregularity in any sanction for a proceeding, unless in the opinion of that court, a failure of justice has been in fact been occasioned thereby. non-recording of 313 or not proper recording of 313 is a failure of justice, because 313 is the first instance when the trial judge comes in direct contact with the accused. And the value of 313 is kept such, my lord, he is not even administered oath that you can say whatever you want. And the funny thing in this case, my lord, if your lordship has seen the 313.
There
he
is
has-
nothing funny anywhere.
No, my lord, why I'll say why not. 313, he has said that he has committed everything. My lord will take the judgment at para 25. He has admitted everything. I would say it's total non-application of mine by the trial judge. Why, my lord? Page 25, para 4 of the judgment.
Is it a never happening event?
No, my lord, I'm not saying that. I'm not saying that.
And
It's
what about
coupled.
his explanation at the last?
Yes, everything.
Is it an explanation of a person of unsound mind?
I would say that, my lord. That's what I'm saying.
Good.
That's what I'm saying. My lord will say
This is funny.
paragraph 25.
That is funny.
No, my lord. Let's say see paragraph 4. My lord will take up paragraph 4 of the judgment at page 25. What the trial judge has done. Prosecution in this case examined as many as 8 PWs, including the MO and IO. After recording evidence of prosecutor's witness, the accused person was examined under 313 CRPC. With respect to the incriminating evidence surfaced against him and evidence on record. His plea was of total denial and false implication. Where from this has come? He further declined. Yes, he further declined. His plea was of total denial and false implication. None of the questions he has said. None of the questions. My lord will say why I said, why travesty of justice? This citation, my lord, of the Supreme Court, my lord will take up paragraph 23. 2023 SCC Online SC 564, para 23, my lord. The duty of the presiding judge of a criminal trial is not to watch the proceedings as a spectator or a recording machine, but he has to participate in the trial by evincing intelligent, active interest by putting questions to witnesses in order to ascertain the truth. While referring to a decision of Lord Denning versus so-and-so, the trial learned judge has said that it is a duty of the judge to ask questions to the witnesses when it becomes necessary to clear up any point that has been overlooked or left obscure. Then he goes on to say as under. Non-compliance of 165, where the trial judge had the power, where evidence had come that all the witnesses had said that something was wrong with him. He was being treated in mental hospital. Why 3-4 months? It was just a matter of 3-4 months. Why record was not called from that hospital? The judge had the power. That is why I say, my lord, it's funny because a travesty of justice. In fact, if a lordship goes to the records, he was granted bail. He could not afford bail because there are 20,000 security he could not take up. He was granted bail, but all throughout he has been jailed. And my lord, Rina Hazarika says, Rina Hazarika, paragraph 19. Paragraph 19 says, if whatever is said by the accused in his 313, whether it is relevant, irrelevant, whether it is accepted, not accepted, it's a matter of fact. But that has to be taken into consideration. A finding has to be brought into this entire judgment, except that paragraph 4, where it says that 313, it was total denial. There is no mention of what he has said in 313. That has been not dealt with. And our High Court in that Bangla Bhakti page 45 has, paragraph 45 had said, the person who has said that he is not guilty in while framing of charge, why if he has admitted something on the backdrop of facts that he was having some mental illness, why was that fact not considered? 313, there's no whisper in the judgment, impugned judgment. One man judgment of our division bench, my lord, one more. This is of 2023 SCC Online, Guwahati 4181. Similar case, my lord, here, one girl, PW1 in this case, she had stated that he was mentally unsound. Here also relatives. The girl, the accused was the cousin of the girl. Nobody else has said, but only the girl has said. So Lordship takes up, going after all these things, Lordship takes up paragraph 61. I'm relying on them. Paragraph 61 and 62 says 465 and 461 CRPC is taken care of. Then section paragraph 63. In view of the reasons stated above, there has been failure of justice, and as such, we are not in agreement with the conviction of the appellant by the trial court. We accordingly hold that as sections 328 and 329 CRPC have not been followed, the trial was vitiated. The benefit of doubt that the appellant was of unsound mind, incapable of defending himself, would have to be given to him due to lapses on the part of the police and the magistrate/court. Thus, the conviction of the appellant under section 302 is set aside. The appellant is accordingly acquitted of the charge under 302 IPC. Consequently, impugned judgment dated so and so is hereby set aside. Here, 5 witnesses, all related. This citation, only one witness, she was the daughter of the deceased. She was also related to this accused. And only she had said in her cross-examination that he was having mental issues. My lord, I'll give the relevant paragraph where she stated. Paragraph 12 in that judgment, paragraph 12, my lord, the next page. Paragraph 12, there's no page number actually. Paragraph 12, the next page, my lord, in the middle. 5th line from top. In her cross-examination, my lord, there's a word material exhibit 1 after that. In her cross-examination, PW1 stated that the appellant was her cousin brother, and that it was a fact that the appellant was a mentally unsound person, as he used to sometimes roam around with a knife and or axe. PW1 also stated that there was no quarrel between the occurrence of the incident and the elder father, that is the elder brother of the deceased and father of the appellant. My lord, what I am on is mandatory provisions of a trial, the safeguards for an accused who is of mentally unsound were not followed, which attracts 465 CRPC. A simple way out would have been section 165 of Evidence Act. When the main witnesses, they may not be independent, but they are the only witnesses. Except them, there's a neighbor who does not say anything, and IO and MO. All have said that he is unsound mind. Trial should have stopped there before taking up the 313. 313, he admits everything, but there's no reference in the judgment what he has admitted. Rather, a contrary thing has been admitted, that he is of total denial. which again violates Rina Hazarika judgment of the Honorable Supreme Court. Whether it is my defense or whatever, 313, whatever I have stated, has to be dealt with. Under such circumstances, my lord, the trial is vitiated and he has the benefit of doubt to be acquitted. But my lord, then comes the provisions of Mental Health Care Act, Section 103. What is to be done with him?
Mr. Bhattacharya, what
Madam.
is the relevance of paragraph 19 and 20 of Rina Hazarika?
My lord, 313, the
Right, 313.
313
And paragraph 4 of the judgment,
judgment,
right?
that is,
Now, if we read paragraph 19,
my lord.
subject to my little understanding,
Ma'am.
if he takes a defense there, under section 3131B, then the court cannot ignore that defense. It has to be considered and discussed, right? This is my little
My lord,
understanding.
yes, yes, ma'am.
If I read this 313 in isolation simply, without the cross-examination part of the prosecution witnesses, there appears to be no defense.
No.
No, but because we have to see the every case decides on its own facts and circumstances. So that is why since you have strenuously asked that Rina Hazarika
Ma'am.
comes into picture and is to
Ma'am.
be applied
Yes, yes, I get it.
whole hog,
No, not whole, why I say,
right?
I
No,
understand
no,
your question. ma'am.
because you have gone so fast.
Yes, my lord. Why I had given
That is why you have said. So I have just,
I had
so
given,
with a
I had,
calmer mind, I read again
my lord.
that how Rina Hazarika can be made applicable. Then it speaks about the defense.
My lord,
But if we see 313 here,
my lord.
forget about this mental unsoundness, everything.
My lord, yes, yes.
There is no defense kind of thing. In fact, there is admission. Whether it is of unsound mind or not, that is a different issue. But para 19 and para 20 says of Rina Hazarika, when there is a defense,
My lord.
that has intrigued me.
My lord, what I'll say, what I'll submit. Let us forget this case. Let us for the time being. Suppose my friend, I come to know from somewhere, my friend is saying something against me. Everywhere. I assault him. And then in my defense, when it's asked, what do you have to say?
No, because.
Why, my lord, the last question,
Mr.
section,
Bhattacharya,
question
because
11.
of that fact, I am pointing out this fact. Because of the fact, if you throw 10 judgments, we have to read all the
Yes,
10
ma'am,
judgments.
I get it, I get it.
And after that, we find 2, 3 relevant, then
Yes, ma'am.
others 7 irrelevant.
My,
That is also a point to be noted,
my,
right?
my answer
That is
question-
why I have pointed
My
it
answer
out.
is question 11 at page 21 of the paper book. He has admitted everything. Yes, I have done. Yes, I have done. Yes, I have done. He was asked, why have you done? What else do you want to say? Question 11 at page 21 of the paper
Now,
book.
what else do you want? Please,
Yes, yes, madam. What else? What
why,
else do you want to add?
please don't make submission.
My lord,
Let us see the question first.
my lord.
He said, what else do you want to add?
My lord.
He has not said why you have done so.
My-
Please,
my lord. So, is
there are
it not my
nuances,
defense?
there are nuances. It is not that he has
My
put
lord,
something.
yes. Is it not my defense? Howsoever bizarre it may be or may not be applicable.
What bizarre?
No, why I'm saying a father, a son killing his father because not allowing him to marry a girl. That is his defense. I told my village, I loved a village girl named so-and-so and I wanted to marry her. And when I told this to my father, he did not agree. He did not agree. This fact itself, my lord, coupled with Bangla Bhakti judgment, says that he evidence, whatever he has stated, it may not be accepted by the court. Why I am ascertaining on Rina Hazarika, he had said something. He had said something. The reason for him killing his father. That has not even been dealt with in the judgment.
The Bhattacharya, law is not mathematics. Law is not mathematics. Every facts are is to be considered and is to be appreciated. Okay, we'll take note of it.
In that situation, my lord, my humble submission is 329 not being followed.
329,
329 CRPC not being followed. which
165 not followed.
together this vitiates brings in 465 of CRPC. So my defense, the moment I enter defense, my ability to enter defense ought to have been verified. And that is amply clear in the Bangla Bhatti judgment and the Upen Basumatari judgment. That you need to, if there's any evidence, your lordship had asked that all the,
Right.
my lord.
We'll come back.
My lord.
Mr. Hazarika, sorry, Bhattacharya.
My lord.
Mm, From your submission, it looks like that firstly, section 101 of the Evidence Act. Prosecution has to establish its case for an offense, for a charge under section 30. Then there are two parts to it thereafter. One is plea of mental unsoundness.
84.
That is to carve out an exception.
Right.
Right? That will be under section 84 IPC. And one zero five. That is one. And the second part to it regarding 328 CRPC, read with 165 CRPC. Now, which case you are arguing?
My lord.
Which case we have to deal with?
320. Why else?
Tell me specifically.
329 read with 165. Along
That
with
is,
this,
you are arguing 328
my lord.
and 165.
Why my reasoning, my lord?
No, no,
My-
no, I am,
Yes.
we have to deal with
yes,
it
yes, yes. 320.
specifically,
329 read with 165.
not 105
My
Evidence Act. read with-
my stand is 329 because once materials have come before the honorable court, trial ought to have stopped. And why my clarification, my lord? 84, my lord. It may so happen today when the crime is committed, I am mentally unsound. I am arrested. I have been taken to the medical officer. He says he is mentally unsound. When I'm produced for physical examination, magistrate court, after going through that report, under 328, he or she will stop everything that this person cannot be proceeded with. That is the mandate. Now, in due course, I come out of the illness. Process will go on, summons will come, trial will start. Then 328 does not stay. Then it falls upon me that on that day, I was not mentally, I was mentally. ill.
Because the trend of the prosecution witnesses is regarding
80.
section 84 IPC,
80,
read with 105.
my lord.
And that has been somewhat diluted by the explanation of the accused in 313, right? To an extent. Whether he was mentally unsound or not, that is one part. And thereafter, during when the other parties that related witness they have consistently said in their cross-examination that he is a person who is having meditation because of mental unsoundness or mentally ill, whatever. So your line of submission, it seems to us that it should be the provisions of section 328 CRPC should have been resorted to by the trial court. And the trial court should have invoked the provision of 165 evidence. This is one part. So your submission is mainly concentrated on that part,
My lord, yes. Non-compliance of that,
not
Comes 465.
notwithstanding the section 84 IPC
my lord,
and
yes.
read with 105.
Non-compliance of
Because
this,
to bring out a case under 105,
my lord.
after say assuming that prosecution has discharged his one pardon under 101, then it is to be, the standard is to be the preponderance of probabilities. And preponderance of probabilities for bringing a mental sound aspect, unsound aspect. It is not only making a mention of unsoundness, it has to be supported by some
Documents.
documents, right? So here, the status of the witnesses, the trial court or any court cannot be oblivious to. I'm making it quite clear.
Yes,
We
ma'am.
have to see, because at one time they want to say the truth. And there are situations, the Supreme Court has said in many cases. But at the same time, trying to carve out an exception so that he is also taken out to the general exception. And there is a proverb in Assamese, Hapu Moril, Lathiu Navangil. Right? This is one part to it. The other part is 328, 165.
320,
So you are considering on 328, 165.
329, session code, 320.
329. Okay.
No, what I'm saying is 329 is the word is shall. That is my main submission, my lord. 329, 1. If at the trial of any person before a magistrate or court of session, it appears to the magistrate or court that such person is of unsound mind and consequently incapable of making his defense, magistrate or court shall in the first instance. Now, if when my submission is, my lord, I am basing my submission on that Upen Basumatari judgment. There was the daughter of the deceased, also the cousin of the accused in that case. She has said that he was mentally ill. That was one witness. Only one witness who had stated that in that case. Here 5 witnesses, assuming they are, yes, they are not independent witnesses. But when a fact has come, just to clarify it or just to negate it, that it's a false claim, the judge had the power. Now, 329 not being considered or not followed, it vitiates trial under 465. And as of my lord 313 statement that I admitted, I fall back on the judgment of this Honorable Court in Bangla Bhakti, paragraph 45. Similar like this case. Yes, my lord, it can happen. I have said I am not guilty. But in 313, I say, yes, I have done this and this. But all the factors have to be seen. Whether he was a normal person, whether somebody of unsound mind, everything has to be considered. Why he had said that. There are cases, my lord. There are cases where he said, yes, this has happened. So in due course of fight, I killed him. Otherwise, he had pleaded not guilty in at the time of framing charge. But that was the same person standing before the trial court. That is my humble submission, my lord. 329 is the major thing. When anything has come, and suppose he was taking medication, I understand that is may not be relevant. It is stated that he has been taken to Tezpur Mental Hospital. So government hospital records could have easily been called for. That is the power under 165. In fact, 165 goes to says any relevant or irrelevant fact. Coupled with all this, my lord, para 4 of the impugned judgment, total non-application. That my 313 I have totally denied. That is my humble submission.
Yes.
One more thing, my lord, there's a report from the jail that he is suffering from mental illness. It was called for by your lordship. It was sent by 10th May 2025. Already submitted, my lord. There is 2-page report, my lord. No, it may be in the IA file. Case number is IA mentioned. The report says, sir, I have the honor to state that convict Abul Bashar have been examined by me. He's a psychiatric patient. He has been under treatment at jail under Dr. So-and-so, who visit Morigaon jail every month. He's a mentally ill person. He's not violent. He is being given medicines as per advice of so and so.
Is suppose, what is the implication of this? What will be the,
My lord, we had brought it because of the IA, because as per your lordship's judgment in Puniram Nath, that a mentally unsound person cannot be kept in jail. He has to be transferred to a psychiatric ward.
Ah.
We had called for this while pressing the IA, but subsequently lordship said that we'll dispose the appeal. That is on record, my lord.
what is, this, number of Nidham Nath?
My lord, I'll give a copy. That appeal is still pending. He's not, he is in.
No, I discuss the provisions.
Yes,
that is
ma'am.
why.
103 has been elaborately discussed.
So,
And in fact, that has not yet been complied in that case.
Criminal 160 of the laws of
Copy.
84.
In fact, we have moved another IA, my lord, it's pending. The directions have not yet been taken up. I'm not wrong, from paragraph 15 or 16. Subject to paragraph 15, 16 it should be. Provisions are
this is,
discussed.
this is for, person, this is applicable for a person, who are undergoing sentence also.
Undergoing sentence.
So
Because
he has to be
10
kept
yes,
somewhere.
103 says, CRPC
Suppose,
does not.
suppose your appeal is dismissed, suppose,
My lord,
then still this is applicable,
my lord.
that he has to be kept
Right.
outside the jail.
Because CRPC does not say, but the Mental Health Care Act. Accused, word is accused, madam. CRPC always says accused.
Right.
If I'm, CRPC 335 says, my lord, if I'm acquitted, suppose I'm acquitted on the ground of this 328, there are two options before this honorable court. Either I may be shifted to mental asylum or something, or a bond has to be taken from my relatives that they will look after me. That is 335. But CRPC, my lord, everything, everywhere the word is accused. But this act, Mental Healthcare Act, it specifically says, section. Definitions. But section 2W of the Mental Healthcare Act says prisoner with mental illness means a person with mental illness who is an under trial or convict of an offense.
There, rule 10. Method, modalities, procedure for transfer of prisoners with mental illness.
Right.
Transfer of a prisoner with mental illness to the psychiatric ward of the medical wing of the prison or to a mental health establishment set up under so-and-so, or any other mental health establishment within or outside the state shall be in accordance with the instruction issued by the so-and-so state government. If you have the Mental Health Care Act,
My lord,
103,
my lord.
subsection 6.
Appropriate government shall set up mental health establishment in the medical wing of at least one prison in each state and union territory. And prisoners with mental illness may ordinarily be referred to and cared for in the said mental health establishment.
Suppose your case is not in your favor, suppose.
My lord.
Whether the state government has any
Only Tejpur, my lord. Central Jail Tejpur.
Tejpur,
Tejpur. Only there, as per my information.
mental health establishment is there, separate,
Separate.
where he can be taken care of, suppose.
My lord.
So this is the provision where, suppose prisoner means maybe
Both,
under trial
both.
or maybe
Both
prisoner undergoing sentence also,
defined here. 2W, section 2W, it is.
2W.
2W. Specifically defined here.
Because three situations, one is at the time of commission of the crime,
My lord,
second during the
Trial.
course of the trial,
present.
third is undergoing sentence. So all these aspects are to be looked into.
Right.
2W.
2W, prisoner with mental illness. Prisoner with mental illness means a person with mental illness who is an under trial or convicted of an offense and detained in jail or prison. Your lordship. The lordship takes up CRPC 334 months. There also the provision is there, what is to be done.
Now CRBC will be applicable to
But
BNSS.
this was at the same provision, madam. BNSS 360, 370 almost. 367 is 320.
Yes.
And CR, if I am acquitted, that is under
Ah.
334, if I am acquitted,
Ah.
then comes 335, madam. After acquittal, person acquitted on such ground to be detained in safe custody. Whenever the findings state that the accused person committed the act alleged and the magistrate or court before whom or trial has been held shall if would act but for the incapacity found have constituted an offense, order such person to be detained in self custody in such a place and manner as the court may think fit. 2, order such person to be delivered to any relative or friend of such person. 2 is important. No order of detention of the accused in a lunatic asylum shall be made under clauses A1. Otherwise, then in accordance with the rules of state government have made under Indian Lunacy Act. My lord, this act has been replaced by Mental Health Act of 1987.
Reflected. BNSS, 370.
374, it is reflected. This act has been repealed by 1987 Mental Act, subsequently 2017 this act. Same provisions, my lord, no difference. 374. 374(2), no order for detention of the accused in a public mental health establishment shall be made under clause A of subsection 1. Otherwise, then in accordance with such rules as the state government may have made under the Mental Health Care Act. of
Whether state
2000.
government has made any rules.
My lord, that is the only, there is a rule, my lord. Transfer of prisoners, my lord.
No, this has to be under Mental Health Care Act.
Mental Health Care Act.
The rule is to be framed under Mental Health Care Act.
Rule, Mental Health Care Act. my lord. My lord, that rule 10 that your lordship has pointed out in that Puniram judgment. My lord, mental health care rights of prisoners with
Okay.
mental illness rules. State government has not made, but section 10 says, section 11 says. Rule 10, my lord, transfer prisoners within the state shall be in accordance with instruction issued by central government or state government as the case may be. Central government, I'm told there's some rules. Oh, this is the only rule, my lord. I'm sorry. Why I'm showing 374 is he can be given to his relatives provided they give a bond. Otherwise, it's a mental health institute.
How this can happen? Suppose the order is to detain, suppose on ground of unsoundness of mind, then either 374 1A or B.
B.
Now, if for a B to happen, there has to be an application
Mm.
from a relative or friend.
My,
We don't know,
so it has to be before
we
that.
don't know about that.
It is not done.
It is uncertain.
Admittedly, it's not done.
Then invariably it should be A then.
A. And for A, it is Tejpur Central.
And thereafter we have to read 378.
Yes.
Whenever any relative or friend of any person detained under so and so, section
Desires.
374 desires that
We
he
deliver
shall
to-
be delivered. And he can make an application.
yes, yes.
State government will have to reach a satisfaction
Mm.
that he
Before the
can be
state.
delivered.
My,
So 378 will come later on.
later, not now.
As of that, we are not sure whether
Right, yes.
his friend or relative will
Yes,
take care of him. As long as he was there, his father was taking care of, maybe
yeah, my lord, rightly. I just pointed out the provision.
his brothers might not take care. No relative may be available.
In fact, the evidence has come that way, that he, since he's mentally unsound, father was keeping. him.
Father was taking care of, that is what they say.
Yes.
It looks like that brothers with families, they are not likely to take care of their. If he is mentally ill, yes.
Lordship, in a case in hand, the
First is
prosecution-
whether it is the case 101 is complied with or not.
Lordship, the prosecution.
Evidence side.
case- Yes, my
How?
Lordship, because the accused person is found inside the room was locked. And your Lordship, as per evidence of PW seven, accused was found, she saw accused murdering.
That is exaggeration. If we read PW 1 and 2. PW 1 and 2, she said also the brothers came earlier. 1 and 2 said they found the door locked.
Locked, but
The accused and his father,
yes,
they were inside
they were.
and they broke open the door.
Yes,
So by that time, father was injured in an injured condition. How can PW 7 who said that she ran after that part?
It has come out
goes.
in evidence. my
That part goes. Don't
Lordship.
make that submission.
Evidence, Lordship, 106.
That
Lordship,
part is not reliable.
my lord. Then your Lordship, he should discharge his burden, but he was not there.
No,
Yes,
you have at first referred to PW 7,
my lord.
right? Suppose 101 is not complied with. We are not going into 105 and all this. Mr. Bhattacharya has not submitted anything. But you have to stand on your own leg.
Lordship.
PW 7,
My lord.
that part is,
Lordship. is
embellishment.
7.
that is embellishment. She has
Yes.
improved.
My lord.
She said,
lord.
PW 7, see,
Page 15. Page 15.
if I have remembered correctly.
Line number 4,
Aha.
accused and the deceased slept.
Brothers of the accused went to the PO first. I
Yes.
followed them. Right?
Right.
Cross.
Yes, brothers of the accused went to the PO first.
I followed them. And brothers going there found the door locked
Locked.
and they broke open the door. And they, after breaking open the door, they found their father in an injured condition lying on the floor and the brother with the dagger. How can she see that?
Then the Lordship may
That
discuss.
is
but
embellishment.
Lordship, one part, murdering, seeing murder, she
No.
might not see.
Bro, this part, you have firstly pointed out.
But your Lordship, presence, he did not deny. Because all the witnesses, they say he
yes.
was very much present.
Tell me,
there.
this part goes, I
My
am
lord.
saying. This is an embellishment.
My Lordship.
So by what are the circumstances? Because it is not a case of direct evidence.
Yes, my lord.
What are the
But Lordship, in
circumstances?
this case, which has been, that
Firstly,
case,
first circumstance,
when an offense has been committed inside the four corners of the room, my lord, it was committed, it was inside, like it was around 9:10 PM. And accused and the deceased was found together inside the room. And accused was holding a dagger. Lordship.
what are the
prosecution-
circumstances? Tell me, what are the circumstances that is
Lordship, these are the circumstances. He was found inside the room,
Please listen our burden.
my lord. He was found inside the room, door was locked from inside. He was carrying the dagger, your lordship.
And that the injuries are consistent with dagger or not?
Doctor, my lord, that was 6. Inside piercing wound, my lord, on the vital part of the body, on the chest, then
Medical evidence,
lordship PW 6.
PW 6. What did he say?
But he said.
Sharp
that
force,
check
sharp.
hypo-
Sharp,
Yes,
major heart as a result of sharp.
yes.
force.
Sharp force.
So dagger could be a sharp force.
Yes, ma'am.
Okay. This is one.
Yes,
Inside the room,
my lord.
they used to live together
Yes.
in one house,
Yes.
father and
My lord.
son.
Door was locked from inside.
Door was locked. Then he owed an explanation under
Yes.
106. And his explanation is in favor of the prosecution.
Yes, so what more? Now, lordship, the prosecution could discharge his burden.
Ah,
When they have taken the plea, as regards the mental.
Mental
soundness,
illness.
burden is on them, which they could not discharge, my lord.
that is what one under 84 is discharged or not discharged?
Teachers by them.
Why?
Mere taking plea will not do, my lord, and whether the stand.
How a
taken-
mental unsoundness is to be proved?
Lordship, whether at the time commission of the crime he was suffering from any mental illness or not. That the defense could not prove anything, although they have taken a plea in the cross-examination by a crafty work of a lawyer. Lordship, but no plea, no document has been submitted by them as to substantiate their claim that he was suffering from mental illness, my lord, at the time of commission of the crime. And your lordship will kindly see section 3, first section 84. Act of a person of unsound mind. Nothing is an offense which is done by a person at the time of doing it, my lord.
It is otherwise homicidal death.
Yes, my lord.
Okay.
I'm giving emphasis on a sentence at the time of doing it. By reason of unsoundness of mind, is incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law.
At the time of doing it.
Yes, my lord. So crucial
What
point-
they said? What they said?
They don't say at the time, my lord, you were suffering from mental illness. And my lord, as per evidence of PW1 cross-examination, accused was in mental hospital, Tezpur, prior to 3-4 months of the incident. He was on medication. But PW2 says the accused is an innocent person. As because of my brother accused was mentally ill, my father kept the accused with him. He was on medication at the time. And PW3 says the accused was suffered from mental illness. He was also taken to Tezpur Medical Hospital, kept there. And 4 says the accused was suffering from mental illness. He was once admitted in Tezpur Mental Hospital. Before this incident, his treatment was going. So, then 7 says the accused was suffering from mental illness. And he used to take sleeping tablets. Apart from that, there's nothing.
Okay, then.
Now I put your lordship to section 321 CRPC. One, if at a trial of any person before a magistrate or court of session, it appears to the magistrate, my lord. So, lordship, it is up to the magistrate to decide, my lord, on his appearance, my lord. Or court that such person is of unsound mind and consequently incapable of making his defense. The magistrate or the court shall, in the first instance, try the fact of such unsoundness of an incapacity, and if the magistrate or the court, after considering such medical and other evidence as may be produced before him or it, is satisfied of the fact, he or it shall record a finding to that effect and shall postpone further proceeding in the case. Lordship, as per my submission, my lord, from his appearance, nothing could be discernible that he was suffering from mental unsoundness, and as such, there is no lordship possibility on the part of the magistrate to discharge his burden of section 320. Then 321A, if during trial, the magistrate of the court of session finds the accused to be unsoundness of mind, he or it shall refer this person to a psychiatric or clinical psychologist for care and treatment, and a psychiatrist or clinical psychologist, as the case may be, shall report to the magistrate or court whether the accused is suffering from unsoundness of mind. Lordship, here the first evidence, it was taken on the month of, my lord, 25 to 2016, And it goes on, my lord, and in September, 313 was recorded. 313, your lordship, kindly note.
From February to September.
February to September.
Hmm.
September 2016 and date of occurrence, my lord. 36, 2015. Oh, no, 29, 16.
February 2016 to
February 2016 to September 2016. And your lordship will kindly note his answer in 313. It's none of a unprudent person, my lord. It's of a person with sound mind. And when the prosecution would stand on his own legs, his answer would give additional link to the chain of circumstances. The reason for killing his father, my lord. As such, your lordship, I don't think your lordship, although apart from some procedural defect, your lordship, there are irregularity. As regards, lordship, the honorable trial court has observed that, that it amounts to total denial, lordship, maybe irregularity, which is not going to the root of the prosecution case. Relying on judgment. Indian Laxmi, our 2022-1 SAC 21. Two thousand two, one SAC 21. Roshi, may I refer para 7? Para 7. Section 84 of the Indian Penal Code provides that nothing is an offense which is done by a person who at the time of doing it, by reason or unsoundness of mind, is incapable of knowing the nature of the act or that what he is doing is either wrong or contrary to law. The section forms part of chapter 4 dealing with general exceptions. The importance of the chapter was highlighted by Lord Macaulay before the House of Commons at the time of introduction of the bill as under. This chapter has been framed in order to obviate the necessity of repeating in every penal clause a considerable number of limitations. Some limitations relate only to a single provision or to a very small class of provision. Every such exception evidently ought to be appended to the rule which it is intended to modify. But there are other exceptions which are common to all the penal clauses of the code or to a greater variety of clauses dispersed over many chapters. It would obviously be inconvenient to repeat this exception several times in every case. We have therefore placed them in a separate chapter, and we have provided that every definition of an offense, every penal provision, and every illustration of a definition or penal provision shall be construed subject to provision contained in the chapter. The principle embodied in the chapter is based upon a maxim, actus non facit ream, nisi mens sit rea, that is, an act is not criminal unless there is criminal intent. Under the Evidence Act, the onus of proving any of the exception mentioned in the chapter lies on the accused, though the requisite standard of proof is not on the same as expected from the prosecution. It is sufficient if an accused is able to bring his case within the ambit of any general exception by the standard of preponderance of probability, as a result of which he may succeed not because that he puts his case to the hilt, but because the person given by him cast a doubt on the prosecution case. In statement of MP versus Ahmadullah, this court held that the burden of proof that the mental condition of the accused was at a crucial point of time, such as is described by the section, lies on the accused who claims the benefit of this exception by section 105 of the Evidence Act. The settled position of law is that every man is presumed to be sane and to possess a sufficient degree of reason to be responsible for his acts unless the contrary is proved. The mere incident of the accused is not enough for availing of the benefit of the exception in the chapter 4. In a case where an exception under section 84 of the Indian Penal Code is claimed, the court has to consider whether, at the time of commission of the offense, the accused, by reason of unsoundness of mind, was incapable of knowing the nature of the act, or that he is doing what is either wrong or contrary to law. The entire conduct of the accused from the time of the commission of the offense up to the time of sessions crossing comments is relevant for the purpose of ascertaining as to whether plea raised was genuine, bona fide, or an afterthought, dealing with a plea of insanity, the scope of section 84 IPC, the attending circumstances, and the burden of proof. This court in Dayabhai Chaganbhai Thakkar versus State of Gujarat held. It is fundamental principle of criminal jurisprudence that an accused is presumed to be innocent, and therefore the burden lies on the prosecution to prove the guilt of the accused beyond reasonable doubt. The prosecution, therefore, in a case of homicide shall prove beyond reasonable doubt that the accused caused death with the requisite intention described in section 299 of the Indian Penal Code. The general burden never shifts and it always rests with the prosecution. But section 84 of the Indian Penal Code provides that nothing is an offense if the accused at the time of doing this act, by reason of unsoundness of mind, was incapable of knowing the nature of the act, or that he was doing was either wrong or contrary to law. This being an exception under section 105 of the Evidence Act, the burden of proving the existence of circumstances bringing the case within the said exception lies on the accused, and the court shall presume the absence of such circumstances. Under section 105 of the Evidence Act, read with the definition of shall presume in section 4 thereof, the court shall regard the absence of such circumstances as proof unless, after considering the matters before it, it should believe the same circumstances existed, or their existence was so probable that a prudent man ought, under the circumstances of the particular case, to act upon the supposition that they did exist. To put it in other words, the accused will have to rebut the presumption that such circumstances did not exist by placing material before the court sufficient to make it consider the existence of the said circumstances so probable that a prudent man would act upon them. The accused has to satisfy the standard of a prudent man if the material placed before the court, such as oral and documentary evidence, presumption, admission, or even the
Okay.
prosecution.
What about 329? Is there any authority?
I'll be basing it. Actually, I'm not wrong.
Because appellant side has placed on section 329
Yes, ma'am.
more than section 105 Evidence Act or section 84 IPC.
After the break.
Yes.
Recorded in 2023 live law Kerala 102. I don't know. I'm sorry. Yasin Sunu versus State of Kerala. Para six,
See,
yes. Live law, ये तो Google search করে পাবে। Indian Parliament. SUNE versus State of Kerala. Here, relevant statutory provision of 329 has been discussed a lot. Para A, going by the statutory provision, the essential condition for the applicability of this section is that it must appear to the court that the accused brought before it is of unsound mind. The word appears in the provision is guidance for construction. It refers to a circumstance with some indication that makes it appear to the judge that the accused is of unsound mind and consequently incapable of making his defense. Forming such an opinion on way or another constitutes the first stage of the proceeding. Certainly, the word appears in the provision is of a lesser degree of probability than proof. The presiding officer is a judicially trained personage who would form such an opinion with utmost care, protect the accused's interest. If there is something in the demeanor of the accused or in the facts of the case which raise doubt in the mind of the court that the accused is of unsound mind and consequently incapable of making his defense, it is obligatory on the court to try the said fact before proceeding with the trial into the charge. If it necessitates embracing upon the next stage, the court has to record such medical and other evidence as will be produced before it, that the court is required to apply its mind to the evidence produced before it and record its finding as to whether the person in question is of unsound mind and consequently incapable of making his defense or not. This is the mandate under Section 329 Acts. While considering the corresponding provision in the old code, Section 465, IV Shivaswamy versus State of Mysore, AI 1971, SC 1638, the Supreme Court held that the section requires that there should be an inquiry if it appears to the session judge that the accused was insane, but if it doesn't appear to him so, it is not necessary that he should conduct a regular inquiry under the second link. The Supreme Court observed that this does not mean that whenever a counsel raises a point before a sessions court judge, he has to straightway hold an elaborate inquiry into the matter. Even examining the accused, it doesn't appear to him that the accused is insane. It is not necessary that he should go further and send for examine the medical witnesses and other relevant evidences. Of course, if he has any serious doubt in the matter, the session judge should hold a proper inquiry. So that's the mandate. Google search করলে পাবো।
Yes.
I'll also rely on these two judgments. They are in my favor.
Which one?
My lord, the first,
Lakshmaya.
Lo- Lo-
Lakshmaya.
Lakshmaya, if your lordship takes up page 225. Lordship, got it?
Yes.
The 10th line from top. The sentence starts with to put it in. Now, to put it in other words, the accused will have to rebut the presumption that such circumstance did not exist by placing materials before the court sufficient to make it consider the existence of said circumstance so probable that a prudent man would act upon them. The accused has to satisfy the standard of a prudent man. If the material placed before the court, such as oral and documentary evidence, presumptions, admissions, or even the prosecution evidence, satisfies the test of prudent man, the accused will have discharged his burden. The evidence so placed may not be sufficient to discharge the burden under Section 105 Evidence Act, but it may raise a reasonable doubt in the mind of a judge as regards one or other of the necessary ingredients of the offense itself. It may, for instance, raise a reasonable doubt in the mind of the judge whether the accused has the requisite intention laid down in Section 299 of IPC. If the judge has such reasonable doubt, he has to acquit the accused, for in the event of prosecution will have failed to prove the conclusive guilt of the accused. I will not go that far, my lord. When the judge came to know that there were something with his mental health, it ought to have stopped it and resorted to 329. And the second judgment, my lord, the Kerala High Court judgment that was just now passed on, although it's a single judge judgment, paragraph 11. I guess page 5, my lord. Yes, my lord. Page 5, paragraph 11. If there is something in the demeanor of the accused or in the facts of the case which raise doubt in the mind of the court that the accused is of unsound mind and consequently incapable of making his defense, it is obligatory of the court to try the said fact before proceeding with the trial into the charge. Facts of the case, my lord. Read with this Supreme Court judgment, it says prosecution evidence. All the prosecution witnesses in their cross-examination has stated. 84 does not, I am not relying on 84, but even that defense, my lord. My lord, one more thing, your lordship asked about the central jail. We had made an RTI in September 2024. A reply had come. This is regarding Tezpur jail having that. They say although there is no designated mental health thing inside central jail, but a separate establishment is there where this sort of people are being treated.
Let's see. Learning council. Responding stage. Yes.
Okay.
Cualquier cosa, por solo hacer.
I can do this one, right, John?
Vosotros en cualquier cosa,
Supplementary list.
7 years.
Josh would take up the other matters.
If I take this one, will not pick up other matters, not possible,
We'll leave.
naturally. Miss Chaudhary will not pick up other matters, not possible to take up. If you want any fixed date, then suggest, we'll pick up. We'll pass orders accordingly. Okay. Let me give you.
The incident occurred on 16/9/94 in the evening,
Occurrence
on 16/9/94.
16/9/19.
94,
Okay,
around 8:30 in the evening.
FIR
FIR was lodged in the morning on 17th at 10
17.
AM.
He was arrested.
Madam,
Arrested?
no. Not that time, because he was only injured. The victim was only injured
He was arrested. The
later on.
appellant was arrested when?
Arrested on the same day, on 17, later,
17.
on 17 itself. On 18/9,
On 18/9,
he was forwarded to the magistrate,
produced.
ADC, produced to the ADC, with a prayer to put him in judicial custody up to 1/10/94.
Say prayer to
Prayer to remand the appellant
for judicial custody.
judicial custody matter. There was another prayer to record his confessional statement.
So confession statement recorded when?
On the next day, that is on 19th, 19/9/1994,
19.
9/1994. So the order of 18/9, it says that he is remanded to Hajot.
Where is that?
It is in file number 2/6
Some.
of the records. 2/6. The last page, my lord. The order is at last page, second last page. The date is not clear. We used the mobile torch
I have
and
the,
saw the date, it's 18/9.
Forwarding. Appreciate.
There is one application for forwarding, then another for
Forwarded.
adding 302.
This forwarding report. Forwarding report is of 89.
18/9.
18. Wait, the 89.
The last page,
54.
my lord, the last page,
Last page.
the last but one page. In the font it is.
Wait. It is senior engineer report.
In the first paragraph, 302 is added. In the second paragraph, third or fourth line. Again, on the next day is produced.
Two fine.
The case diary, my lord, 6 by 6, file number 6 by 6. On 18/9, it is stated that he is being taken to the court, but there is no record that he has been received back.
But in fact, in that portion, I think my prosecutor is completing with the word also whether it is judicial custody or state custody. If you look at the with the CD, I think that the chair was made for judicial custody.
18.
Yes.
Yes.
And thereafter the confessional statement was recorded on
Hmm?
19. On 99, thereafter the confessional statement was recorded. So I do not find any infirmity with the recording of the confessional statement.
Recording of 164.
Because he was, one night he was in judicial custody, on the next day he was produced, given 3 hours time to reflect, and then his statement was recorded.
Let us see the evidence of the magistrate.
My. PW6, page 17. On 99-94, I was attached at the Deputy Commissioner's office, Tifu, as magistrate class, first class. On that day, additional Deputy Commissioner so-and-so endorsed me for recording confessional statement of the accused Meghatimi in connection with Tifu PS case number so-and-so under section 325 IPC. Exhibit 5 is the order passed by the ADC, Mr. A.K. Sharma Roy, and Exhibit 5.1 is his signature, which I am. Thereafter, on the same day, the case records, along with the aforesaid accused person, was produced before me. Accordingly, matter of confession was explained to the accused person and also cautioned him that I was not a police officer but a magistrate, and that he was not bound to give confessional statement. If he did so, it might be used as evidence against him. Thereafter, for reflection, the accused was given 3 hours time. During the reflection period, the accused was kept in an adjacent room under the supervision of my peon. On completion of the reflection period, the accused was again produced before me for recording the confessional statement. Thereafter, again, I explained the matter of confession to the accused person. I also cautioned him that he was not bound to give confessional statement, and if he did so, it might be used as evidence against him. I also explained necessary requirements for the accused person before recording his confessional statement. In spite of cautioning the accused person in the manner narrated above, he intended to give confessional statement voluntarily. Finding the accused person ready to give confessional statement voluntarily, I proceeded to record his confessional statement. Exhibit 6 is the statement, is the confessional statement of the accused. 6.1 and 266 are my signatures. After completion of the recording of the confession, I gave a certificate stating that this confession was voluntarily made and it was taken in my presence. After recording the confession statement, I sent the case record back to the original court. Exhibit 7 is my order dated so and so and is my signature. In cross exams, I have not mentioned the name of the police officer who brought the accused before me in my order marked as Exhibit 7. I have not mentioned in Exhibit 6 that I recorded confessional statement of the accused person at 3 p.m. after expiry of 3 hours, which was given for reflection. I have not mentioned the name of the PM in Exhibit 7, under whose supervision the accused person was kept in adjacent room for reflection. I have not mentioned in my order marked as Exhibit 7 that the accused was kept in an adjacent room for reflection. But he has stated that the appellant was kept in a room under the supervision of his peon. That is at page 57 if you look. Page 57, right-hand column, serial number 3,
57.
57.
Which part?
Right-hand column, serial number 3. Having talked with the accused, explaining to him each of the matter mentioned in paragraph 5 herein under, and cautioned him that he ought to reflect carefully before making any statement, I have placed him in charge of Young and directed the record accused to wait in order that he may have to reflect before making any statement. And on page 56, right-hand column, the accused Miku Timung is brought by the police constable before me at my court on so and so at 3 p.m. to have his confession recorded. So time is done.
Yes.
Now, he retracted in his 313 statement on the.
What do you find from this 164 statement? What is, it is correctly done?
It is correct, according to me.
What are the other circumstances? Because it appears to be a circumstantial evidence.
Circumstantial evidence. The rest, three witnesses, they have
Yes.
said that he has stated before us that he has committed the offense.
Hmm?
So extrajudicial confession,
Which one? Let us see.
PW1.
PW1.
Page 7, madam. He is Prabodh Chandra Bora. He says, I know the accused Megha Timung at Dock. I was working as teacher at Gita Ashram. The incident occurred on 6994. On that day, I was at the residence of Gita Ashram. During the incident, I went to bed after taking meal around 8:30 p.m. I have heard a loud sound asking Ashram Bura, and then I went out. And at that moment, the accused came to me and told me that he had killed Ashram Bura, alias Khogen Doimari, a cook in the ashram.
Yes.
That he has, I went out at that moment and the accused came to me and told me that he has killed Ashram Bura, alias Khogen Doimari, a cook in the ashram Ural. Further, the accused told me that the deceased was killed with a Ural Mari on the road heading to Gita Ashram. I informed the superintendent of the hostel, Mr. Pramod Lalai. He is the informant and he is not made a witness here, Pramod Lalai. And he came along with some local boys and we went to the spot. The accused was also present with him. The deceased was lying on the ground. We found him injured on the head and blood came out of the injured portion. The accused explained that he killed with the Ural Mari. Then we surrounded the deceased and took him to the hospital for further treatment. I also waiting for 2-3 hours. I left the hospital. On the next day, I heard that Ashram Bura died. The accused stayed at his home. In the meantime, Pramod Lalai submitted an Azahar and police went to the spot and inquired the case and arrested the accused Megha Timung, who confessed his guilt before the police. The Ural Mari was brought to the police and seized it. The Ural Mari was identified as produced before the court today, but I did not sign on the seizure list. Now in cross he says, the accused residents are quartered nearer to our school. I did not know the quarrel between them earlier. I did not heard any quarrel earlier. The victim went to the house of the accused and it's eligible. The accused asked the victim to wait, but the victim did not wait. So the accused followed him and killed him, the victim, the victim was a Sopadhara. During that, there was a rumor, and hue and cry around Difu to catch the Sopadhara. The incident was accidentally, I suppose. Had the victim was not silly at the order of his house at night, the incident would not have been occurred as such. The accused told me that the victim was not killed voluntarily and could not know or recognize the said Doimari as stated by the accused. So in cross, it has come out that there was no quarrel between the appellant and the victim. The victim was,
This part of cross, the victim went to the house of the accused.
he went to the house.
This part, that was not said to him, he did not attribute this statement to the accused. The victim went to the house of the and the accused asked the victim to wait. But the victim did not wait. So the accused followed the victim and killed the victim. As the victim was as if the victim was a Sopadhara. This part, he did not attribute to the accused. It is his own.
It seems like it could not be taken out in that so many good words. Otherwise, an allegation is against the victim that he was doing something silly at his house. That the victim was not silly at the order of his house at night, the incident could not have been occurred. Had he been not silly or whatever at my house, this incident could not have happened. Again, he talks about the same night that I have stated that I did not kill him voluntarily. And I could not recognize the person whom I am hit. PW 2 page 10 is Emari Timun. I know the accused on the dock. He is related to me. The accused is the son of my brother, Boyang Timun. So my brother and I live separately. I know Khogen Damari, the deceased, who was a cook at Gita Ashram. I know the complainant, but I do not know his name. The incident took place before Gita Mandir, the school. While I was sleeping, I heard the sound I halla and went out and went to the spot. There is a gathering of people. The Khogen Damari was lying on the ground, sustained injury on his head. Therefrom, blood came out. At that time, some other people gathered on the spot. The accused was also present on the spot. The accused, Sri Megha told me that he killed the deceased with an Uralmari. Again, extract on the extrajudicial confession. I'll put it to it.
Itu nomor. Itu nomor. Apa yang main lagi? Itu sah. Umar. Yes.
The accused also present on the spot. The accused Megha Timung told me that he killed the deceased with an Uralmari. Another extrajudicial confession. The deceased took to hospital for further treatment. I did not stay at hospital. On the next day, I have heard that Khogen Damari was dead. I came to hospital and went to the police on that day. The accused was present at his residence. The Uralmari was brought by the accused and seized by the police. I recognized the Uralmari produced in the court. Police took my thumb impression on the seizure list. Exhibit 1 is the seizure list. So-and-so is the seized Uralmari wooden. Police arrested the accused and took him to their custody. And here it should be cross, my lord. It is not typed. Otherwise it is cross. I did not see the occurrence. I heard after the occurrence. The accused did not come to the hospital at night. On that day, it was dark and rainfall was there. Lots of marked that. It was dark and rainfall was there. The accused thought of him as Sopadhara. I did not kill him intentionally.
Which part?
Cross the last 4 lines at page 11. It should be cross. For the judgment, it is clear that it is cross. Last 2 lines I'll read. At night, that day it was dark and rainfall was there. The accused thought of him as Sopadhara. I did not kill him intentionally.
I did not kill him.
Last you will see the original vernacular
Is the difficulty
melody.
of translation? What kind of typing? System.
It's in another.
You were in jail for what period?
My lord,
You were in
jail for
Hmm.
8 years, 3 months, 22 days
judgment was in the year?
into 2020.
Huh?
2020. So from the date of judgment, it's been 7 years, 2 months. And during the trial, I was for 1 year, 1 month, 20 days.
Yes.
Now if I may please PW three, page 12. This is Ratan Ko. He says, I know the accused Megha Timmu. Really, his name is not Megha, but his name is Meko. He is near Gita Ashram, so I do know him. Say Hogan Doimari was a cook at Gita Ashram. I know him very well. Hogan Doimari is so and so. He was killed by Megha Timmu. 9-10 years before at 7 p.m. the incident had happened and the victim Doimari, Pon Pokai, has been assaulted as informed by our member and next time on the same day that he was dead as informed by the members from hospital. Somebody informed me that the victim and his elder brother both were assaulted. On the next day morning, myself and Vipun Hazarika went to the hospital. There the victim was inquired by one police. We were called to the Gita Ashram by the police officer. The police officer called upon the people and asked them who has killed. On the same day, at the same time, the accused was called by the police and then he confessed that he killed him. The accused told the police as well as us he killed the victim with a lathi while he was roaming nearby after cooking the meal. The police examined me and us. The case was probably instituted by Pramod Bora. In cross, I did not cross him. PW3 says that the victim, who is a cook in Gita Ashram, after cooking the meal, he came out. My house is just adjacent to their ashram.
Who's your?
Mine. He was roaming around. PW1 says he did something silly at my house. PW2 says it was dark and raining. And they
So
say
they
that
did not see anything.
they did not see anything. They did not see
BW 1, 2, 3, they did not see
They are-
anything.
They are taking the statement which I have told.
They sound, they came out, made the accused.
The
And
accused was there.
BW 1 and 2 said that accused said,
One says I went there, brought them out.
and one said yes. You went there.
I went to him, told him that I had assaulted this person.
I've heard
And
this
then he
something. I
called
went
another
out, the
people.
government came to me and told that he killed the ashram Bule Elias Kogan Damini cook in the so in the ashram. Either he the accused told that the disease was killed with a well money on the road heading to
Then Peter
Gita Ashram.
informed the superintendent. Superintendent called some boys and then all of them came up.
He found him injured.
PW 1, 2 and 3, they have not seen anything. They are repeating whatever I have told them.
So what is the distance between the house
It's
of the
adjacent.
appellant and the place where the disease was found lying injured? Anybody said so?
Even the sketch map was not produced. It is there in the CD I have seen, but it is not exhibited. Gita Ashram has some quarters where the teachers reside. The cook is there. My house is adjacent to it. As told by PW2,
You are not associated with Gita Ashram.
I'm not associated.
Then the story would be, if we join the dots,
Right.
that if we accept the 164 statement for a time, that the disease tried to enter his house or attempted to molest. Then accused, seeing him,
Could not
Gave a
see who
blow.
he was, but he saw somebody.
gave a blow, which is Uralmari. Then Dinesh somehow managed to come up,
And he fell.
right? Then he fell down at a place near
Near
Itas.
the house, so immediately I
Then-
went to ask him.
Accused kept the Uralmari in his house, then came. Thereafter, got
Informed
halla
him.
by the injured or by the appellant, we don't know. Then accused went to PW1.
In the
After hearing halla, PW1 came out, accused also
reached.
went to him. Then thereafter said he killed. Killed.
Married later. I have
Ah,
caused grievous.
that he killed. Then PW2. From the evidence of PW2 and PW1,
Come much
it
later.
is not, does not emerge that they were together
He was-
before that.
He came much later.
Accused told. They were told separately, it looks like.
Hmm.
Every time he met somebody, he used to tell. It looks like that. And when police came, he confessed. That part goes. Once he comes under the suspicion of police, it goes. So even if we take this extra judicial confession on one side and the other judicial confession under recorded under 164, these are the two.
Right.
Now both are retracted. Maybe at later stage.
Later course, he says everything is false.
So it has to be true and voluntary,
Now, my lord, the incident took place in 1994.
right?
But by the time his evidence was taken, already 26 years had passed.
When is the evidence was taken?
313 in 2020,
2020.
1994. So he simply said, I deny everything.
It is a case of prejudice also. Expeditious trial. Running the trial for 20-25 years. It is a case of prejudice also. Facing the trial for 26 years itself is a punishment. Sarsin immediately submitted.
Charge sheet immediately in the
When?
month of December 1994.
1990. So the case ended when?
In
With
December
the judgment?
2020. December 2020.
December 20. 26 years.
21 December 2020.
Huh?
Page 26, last one.
Evidence recorded to 2020. 2019 also.
19.
Oh. PW1 recorded when?
PW1 is recorded on 4th day of December
2002. PW2,
2002. No. 2 is 4th of December,
2002.
same day.
PW3, 2004. These are by that additional district magistrate. Then session just started recording testimony of the witnesses from PW4 onwards.
4
It
is
was
the
in
doctor-
July 2019.
19.
And who else said PW1 and 2 only?
1, 2, and 3.
3.
Almost 10 years after the incident.
Told me. Judicial confession, one is extrajudicial confession, nothing else. Medical report, homicidal death. Where is the appellant's house? If the story to be true, because chain of events, there is a case of circumstantial evidence. So all events are to be proved so that the chain is complete to rule out, to pointing to the only possibility that he and only he is the assailant, right? Now, two things prosecution has relied. The 164 statement, confessional statement, and second one is extrajudicial confession, right? Now, he has said that it was properly done, 164. We may not agree to his submission, though he has made the submission. Right. We have to think that this man was an illiterate person. He was illiterate, let me tell you, left hand LTI. Second part is extrajudicial confession. It is standing alone because this ashram, where this ashram was, where is the place where the injured person was found? Where was the house of the appellant? How he chased from his house? If the story of this 164 is to be held to be true, then the prosecution had a duty to prove also. His house may be 1 kilometer. At a distance of 1 kilometer, we don't know. Nothing has been proved. Gita Ashram, where it is, the place where the injured was found, that distance is also not established. Outside, maybe on a road. All this 106 will come in when the accused prosecution has proved all its case, all the events under 101. Then onus shifts to the accused and he owes an explanation to give a plausible answer to it. If the prosecution fails to establish all the circumstances to indicate that yes, he is the man, then he does not owe any explanation. 313 he denied. Right? So what it means is extrajudicial confession and judicial confession. Both are retracted. It has to be true and voluntary. And true is it is to be true. One part of 164 is that he took the injured to hospital. Nobody said. That may not be true. Every aspect is to be true. Secondly, this was an illiterate man where the magistrate who recorded the statement explained what he had written. He had written in English, not to speak of, he does not know even writing Assamese, the accused. He recorded everything in English. in his testimony, he did not say that I have explained what I had written. Now 164 is to be read with section 281. Right? This may go or may not go, subject to your submission. Right? 164(4) and 281(4). And all this extrajudicial confession, they are saying, he said to me, he said to me, he said to me. It is not said to us.
PW do say that he confessed like gathering of people. PW say, do say.
He don't realize it. 11, accused Megha,
Right.
Timung told me,
That he killed the deceased with Quran money.
told me, not us.
I got PW3, page 13. Last question, the accused told to the police as well as us.
I know him, he was coming and he was killed. 9-10 years before, 19 happened. As informed by our members. First part, page 12.
Okay.
He's a hearsay man. He preceded the event to 7 PM. He's a hearsay man.
But this portion, madam, on the same day, the same time, the accused was called by the police. And then he confessed that he.
After police enter the scene, you discard, throw it. Don't take into account. After police enters the scene,
Madam,
you throw it. This man looks like a hearsay man. He preceded the event by 1.5 hours. And what he said, as informed by our members. It is clear.
then
PW1 was the only one to whom the appellant appeared to have approached. And he said 8:30. So all this whether should be taken into account to bring home the charge. In a case of circumstantial evidence.
Going on PW1 and 2, the recovery of the weapon that Madam Ural Mari might not.
That is there is another doubtful thing. If he has chased, that is why there are many gaps. We don't know the house of the appellant. We don't know the Gita Mandir. We don't know the place where the injured was found. It was a public place. How far is the distance? If he had chased from his home, how far he had chased? If he had chased at least 100 meters also, then when the accused was there, Ural Mali was not with him. Where the Ural Mali had gone? After he chased, inflicted the blow, then he coolly went to his house, put the Ural Mali, then come back again, then Halla, then called PW1. This may be true, but these are to be established by reliable evidence by the prosecution. It is not a case that inside the room, that like the other one,
Madam,
under a locked room, son killed father. Door was locked from inside, the previous case.
previous.
Door was broken. Thereafter, all other please. Right. Their accused clearly owed an explanation. Door locked, only two inside the room. Father with injury, son with dagger, blood. He owed an explanation. Here it is an open space. So, pardon automatically does not shift to the accused to give an explanation. He did not give an explanation. He has the right to remain silent. At the same time, he denied extrajudicial confession and judicial confession. So both got retract. Entire burden is up to the prosecution. To be then the chain of circumstances, if you go by Sarda, case may fall. Because it does not shift. These are the dots which have to be.
The police has not. This sketchman.
You cannot look into it. And sketch may be also not substantive evidence. Unless it is brought on record to the evidence, witnesses.
Here, my submission would be because this confessional statement, my submission is properly recorded. Because when I was regarding the detection, that detection was very after considerable period of time without distraction concern. Because my lord here, otherwise my lord he is clearly stated that my lord he has assaulted the thing with the money. That also recovery was also made. And this, my lord, he said that one of the wife, because they, something, so my lord,
We are in 2025. Nazir Ahmed was in 1936. 1830. 1930. Nazir Ahmed was on 164 only. When a thing is to be done in a particular manner, that must be done in a particular manner. Any other manner is.
Or not at all.
So this is 164 Nazir Ahmed. It is still holding the field. And the case is, though everywhere it is applied, read, petition, everybody says, everywhere, civil, criminal, but it is recording of 164 state by the magistrate. So that line is attributed to that. Did you know earlier? So he was, this accused was not explained. See, 281(4). Read it.
the record shall be shown or read to the accused. Or if he does not understand the language in which it is written.
It is English. Magistrate has written it in English. Read.
And he has also stated that he has taken the statement on SMS.
Shall be interpreted to
record
him
shall-
in a language,
Which he understands.
and he shall be at liberty to explain or add to his answers. Now come back to the testimony of PW.
Page
17. Where is that?
Page 59, madam.
Page 17.
17.
PW.
Oh, these are typed, sir.
17.
Is there anything?
Nothing.
Sir, you have to look into minutely. It is a case of life and liberty of a person. If he is a highly educated man, knows English, okay. Otherwise, Nazir Hussain comes into picture. So that part may not stand. Then extrajudicial confession is a weak, not always weak, but it has to be supported by corroborative evidence. So that the chain is complete. Good. Man has been in jail for 7 years,
8 years.
8 years, stood the trial for since
26 years.
1994 till now, 31 years. It is a continuation of the original proceeding, appeal. He is in jail. Tomorrow we'll get, we lost the energy now to be there. Tomorrow, as soon as after the admission, we'll get. I heard Mr. B. Prasad, the council, will make a speech for the appellate, and Mr. R. R. Kosi, learned additional public prosecutor for the respondent states. Those of, place the case tomorrow for part, he dictate the order.